We shall now go on to the last topic for criminal law 2, which is the topic on defenses. Now, there are some defenses which are not so good defenses, and there are some defenses which are good defenses, right? So, for those of you who are not Liverpool fans, please do bear with the slides for this topic. Okay, so we're talking about good defenses, right? What are the defenses that can be used? Now, for defenses, there are specific defenses and there are general defenses. For specific defenses, these are basically defenses which only apply to a particular offense, right? So they are very specific in the sense that it can only be used for certain specific offenses. Can you think of examples? We have done this last semester, right? So the defense of loss of control, the defense of diminished responsibility, right? And also the defense of suicide pact. These are specific defenses because it only applies to the offense of murder, right? It only applies to the offense of murder. So those are that specific defenses. Whereas general defenses are basically defenses that applies for any offense, right? So it applies generally. Of course, there are always exceptions to the general rule. So for defenses, there are basically two general categories also, right? There are defenses of justification as well as a defense of excuse. What are these? Let's take a look at a few examples. Right, if this person raises this defense and say that I did not steal, it was paid for already, is this a justification or is it an excuse? Okay, for those of you who said that it's a justification, it's correct. This is a justification. How about this? I slapped him, but he started it first. Now, this is an excuse. I did not want to do it, but she forced me to. Is this a justification or an excuse? This is an excuse also. And finally, he told me I could take his car anytime. Is this a justification or an excuse? Well, it is a justification. So can you tell the difference between what amounts to a justification and what amounts to an excuse? Now, a justification renders the conduct lawful, right? So no offense has been committed. Again, no offense has been committed. So here are examples of justification. For the defense of consent, we have done this last semester already. So therefore, if for example, for sexual offenses, for the offense of rape, a person may say that, look, I'm raising the defense of consent, right? And if it can be shown that the victim consented, then it will render the penetration to be lawful. Similarly, also for self-defense and for necessity, right? If you can raise this up, basically the law says that what you are doing is lawful if you are acting in self-defense or if you're acting out of necessity. So we will be covering self-defense and necessity because we have done consent last semester already. Now you compare justification with excuses. Now for excuses, the conduct is still considered to be unlawful. However, there are some circumstances which renders the defendant immune from liability, either in whole or in part, right? So what the accused did is still considered to be unlawful. However, due to certain circumstances, right, the defendant will escape liability. Right, the defendant will escape liability. So we will be considering three excuses. First will be duress, intoxication, and insanity. So these are the three excuses, which basically where the act of the accused is still considered to be wrong, right? For example, in the case of the duress is where a person has been threatened with his life, right? And he is basically forced to commit a crime, right? He's basically forced to commit a crime. So he's said to be acting under duress. Now, the crime itself is still considered to be unlawful, but because of the circumstances where he was threatened with his life, therefore, it will render him immune from liability. So we will be looking at this in greater detail, right? But first, let's look at justification, and we start off with self-defense. Now, for self-defense, it's interesting to note that under the Criminal Justice and Immigration Act 2008, it recognizes that this defense exists both in common law as well as under as well as in statute, right? Statutory defense as well as a common law defense, right? The Criminal Justice and Immigration Act 2008 recognizes that in determining whether force used for self-defense is reasonable or not, Section 76 recognizes self-defense as a common law defense, as well as under Section 3 of the Criminal Law Act. So we will be looking at common law, at cases which develop this defense or self-defense, but bear in mind also that it can come under Section 3 of the Criminal Law Act 1967. So under Section 3, it is provided for that the person may use such force as is reasonable in the circumstances in the prevention of crime, in effecting or assisting the lawful arrest of offenders or suspected offenders or of persons unlawfully at large. So let's break it up there, right? So basically, this Section 3 says that one may use force that is reasonable in order to prevent crime or in order to assist or to effect the lawful arrest of offenders, suspected or offenders or persons unlawfully at large, right? So basically, you are allowed to use, in order to prevent crime from happening, you are actually allowed to use reasonable force, right, to prevent it from happening. You are also allowed to use reasonable force to actually lawfully arrest an offender or suspected offenders, right? So they call this the public and private defense. Okay, so public defense is when you are defending other people or other people's properties, and private defense when you're defending yourself or your own property. Now, the burden of proof for self-defense is not on the defendant. So while the defendant can raise this as a defense, the burden of proof is not on the defendant to conclusively prove that he was acting in self-defense. All he needs to do is just to raise evidence to show that he was acting under self-defense, and if it raises reasonable doubt, then he will be acquitted. At the end of the day, the golden thread still remains in the sense that the prosecution is the duty to prove the case beyond a reasonable doubt. So the prosecution will not only have to show that the accused committed the actus reus and the mens rea beyond a reasonable doubt, the prosecution also must show that there was no self-defense, right? There was no self-defense. So it is a burden on the prosecution to do so, right? If the defendant raises evidence that he was acting in self-defense. So for this self-defense, this is the basic outline. We're going to look at first the use of force, and then assessing reasonable force. How do you assess force that is reasonable? Because we have seen under Section 3 just now that you can use force that is reasonable. And finally, we're going to look at this principle that applies for self-defense. It is all or nothing. We'll come to that later. But first, the use of force. And under the use of force also, there are three subtopics, basically, or subsections. First, we're going to look at what happens if you are the one that initiate the violence, and then you have to act in order to defend yourself. Two, we're going to look and see whether is there a duty to retreat or not, right? So if your life is being threatened, do you have a duty to run away, try to escape, or can you just straight away defend yourself? And then we're going to also look and see about the use of force when there is the immediacy of the threat. So let's look at first initiating violence. Right? Now, the rationale for self-defense is that a person is allowed to defend himself only as a last resort, right? Only as a last resort. Under the European Convention of Human Rights, Article 2.2, when talking about deprivation of a person's life, it is only if it was absolutely necessary, right? You can kill a person only if it's absolutely necessary. So the question is that what if the violence was started by the defendant, right? The defendant meaning the person who's trying to rely on self-defense. What if he was the one who actually started the fight? And then when the victim retaliates, then the defendant says that, oh, well, he wants to attack me. I'm going to defend myself. But in actual fact, he was the one who started the fight first. So in the case of Brown, it was held that the need to act in self-defense must not have been created by the conduct of the defendant in the immediate context of the incident, which was likely or intended to give rise to that need. Okay, so I think that this is something that we can all agree. If the reason why he had to act in self-defense was because he started the fight first, then he should not be allowed to rely on the defense of self-defense, because he was the one who created a situation where he had to act in self-defense. But it doesn't mean that this is necessarily the case all the time, right? Just because a person starts the fight, then he cannot rely on self-defense. And this is so you see the under Brown, it says that the need to act must be created by the conduct of the defendant, right? Which was likely or intended to give rise to that need. But what if the conduct of the defendant give rise to something which was disproportionate? And this was decided in the case of Rashford, Court of Appeal decision. And on the facts of this case, basically, the defendant has gone to exact revenge, right? He went to exact revenge. Basically, so he was the one who started, he was the one who looked for trouble, so to say. But the Court of Appeal said that just because he went there to look for trouble, to want to start a fight, doesn't mean that he cannot rule out self-defense. The question at the end of the day was whether the violence offered by the victim was so out of proportion to the defendant's own act, right? So out of proportion to the defendant's own act. So he may have wanted to go there just to inflict actual bodily harm, but then the victim retaliated disproportionately and threatened the life of the defendant. So we can, if it can be shown that the reaction, right, the violence offered by the victim was so disproportionate to the defendant's act, then the defendant can possibly rely on the defense of self-defense. Moving on, duty to retreat. Now, is there a duty to retreat or not? We will first look at the case of Julian, right? This is a 1969 case, and this was a case where the defendant was threatened with a chopper, right, a knife, and he responded by taking a milk bottle, right? These are the milk bottles that were used back then, right, in the early 70s. So the milk came in a glass bottle. So he took a glass bottle milk and he threw it at the victim, right? Because the victim threatened him. Now the question was that should he have done that, right? If he was being threatened by the chopper, should he instead have tried to escape and run away instead of retaliating by actually throwing the milk bottle at the victim? Now the defendant in this case was actually found guilty, right? He was convicted. He's basically on at the first instance, his defense of self-defense was rejected, seeming to imply that he should have actually retreated, right? He should have actually retreated, because if you remember, we mentioned just now that self-defense should only be used as a last resort, right? It should only be used as a last resort. So he should have retreated. Only when there is nowhere to go, then he could have then only he he can use force in order to defend himself. But we see another case later on, right? This is much later, 1985, the case of Bird. Case of Bird was an interesting case. It was about this girl who celebrated her birthday. She was a teenager, so she celebrated her birthday. So she was celebrating her birthday when her ex-boyfriend came, right? Ex-boyfriend came to the party, and the ex-boyfriend, guess who the ex-boyfriend brought? Yeah, the ex-boyfriend brought along with him a new girlfriend. So there was a lot of words exchanged, heated words were exchanged. He left with his new girlfriend, and then he came back later again. And then there was a round two again, and there was quite a lot of heat, a lot of bad words which were used. And what the girl did was that she was so upset that she was holding a glass of wine, right? A glass of Pernod, and she poured it over him, the wine. Now he was very mad, and he actually held her against the wall, right? Held her up against the wall. And what she did was that she took the glass, the wine glass, and she smashed it onto him, right? Smash it onto his face. Okay. So then the question is that, well, is there a duty to retreat? And the answer in this case was that there's no way for her to retreat anyway, right? There's no way, nowhere for her to retreat to. And the court decided in this case that there is no obligation to retreat, right? There's no obligation to retreat. If, right, if the accused if the defendant in the case can show that he or she tried to retreat and then only resorted to self-defense, then that's good, all right. But if there is no effort to try to retreat, right, it doesn't mean that the person will automatically not be allowed to raise a defense or self-defense. We still need to look and see whether the elements for this defense are, are satisfied or not. Now, under the Criminal Justice and Immigration Act that we saw just now, Section 76, paragraph 6, sorry, subsection 6A, right? In deciding the question whether force use was reasonable or not, a possibility that D could have retreated is to be considered as a factor to be taken into account rather than as giving rise to a duty to retreat. So this has been put into statutory footing under this section 76 6A. So therefore, the fact that he could have retreated is just something for the court to take into account. But there is no duty to retreat. So Parliament has confirmed that. Excuse me. And finally, the immediacy of the threat. Where basically case law have held that a preemptive strike is is permissible, right? A preemptive strike is permissible, meaning that you do not have to wait until until the victim attacks you. If you know that the victim is going to attack you, you can take preemptive steps and to defend yourself, right? And to defend yourself. Just like how the US used to say last time, this is a preemptive self-defense, right? We are going to attack we're going to attack them to prevent them from attacking us. Okay, so preemptive strike is allowed according to the case of Beckford. We're going to look at the facts of case later. As long as the immediacy of the threat is proven, right? You can show that there is a real threat that you're going to be attacked. So you don't have to wait until the attack commences. If there's a real threat that you're going to be attacked, you can act in self-defense. So that's on the use of force. Now we move on to the arguably the most important part of this self-defense is how do you assess when force is reasonable, right? Assessing reasonable force. So do you think there is an objective test or subjective test when you want to decide whether was the degree of force reasonable or not. Now, every time we look and see every time we need to decide whether something is reasonable or not, is usually an objective test, right? It's usually an objective test. But let's look at the case and see, right? The case of Ovino lists down the test for self-defense. Right? The test of self-defense was that a person could use such force in the defense of himself or another as was reasonable in the circumstances as he honestly believed them to be. Now, is this an objective test or is this a subjective test? What do you think? Just like a lot of things under criminal law, it is both objective and subjective, right? It has both elements of objective and subjective in it. The subjective test is what were the circumstances that the defendant believed in, right? So we look at it subjectively. Doesn't matter what was the actual circumstances or what a reasonable person would have thought were the circumstances. Here, the test is that what were the circumstances that the defendant believed in, and based on those circumstances that the defendant believed in, was the degree of force used reasonable or not? Right? Was the degree of force used reasonable in those circumstances that the defendant believed in? So Section 76 of the Criminal Justice and Immigration Act 2008 in paragraph 3, right? Basically, Parliament agreed with it and put it in statutory footing. The question whether the degree of force used by defendant was reasonable is to be decided by reference to the circumstances as the defendant believed them to be. So whether first we see subjectively what were the circumstances that the defendant believed it to be, and based on those circumstances that he believed in, then we can decide objectively whether was the degree of force used reasonable or not. But what if the belief of the defendant was unreasonable? So the defendant believed that this was a situation, but objectively no one else would have believed it to be that case, right? So what if it was an unreasonable belief? Let's look at the cases to determine this. Now, the case of Beckford, as we have seen just now on the immediacy of threat. Now, basically, the case of Beckford was a case where the police were chasing after suspected criminals, and but the policeman thought that the criminal, the person that was chasing was a criminal and was armed, and basically was going to use those the weapon against him. So therefore, he actually shot first, right? He shot first before they could actually attack him. Okay, so that's why we talk about the immediacy of threat. Basically, he took preemptive action to defend himself, right? That was the case of Beckford. However, sadly, the person that he shot was actually not the criminal, right? Was not the criminal, right? And the person, the victim wasn't in possession of any weapon, and so therefore the policeman was under no threat. So the question then is that can he still rely on self-defense because he mistakenly thought that he was under threat? The Court of Appeal held that the appellant's belief that the circumstances required self-defense had to be reasonable, not merely honestly held. Right? It had to be a reasonable belief. But that doesn't seem to be what we have looked at earlier, doesn't it? And the Privy Council actually allowed the appeal of the appellant, saying that the test to be applied is that the person may use force that is reasonable in the circumstances as he honestly believed them to be. So if he honestly believed that he had to act in self-defense, right, those are circumstances which cause him to act in self-defense, then that will be the circumstances that he will be tested on to see whether was the force that he used reasonable or not in those circumstances. So the key thing will be that the circumstances must be as he honestly believes it to be, and it doesn't have to be reasonable. right? It does not have to be reasonable. Another case is the case of Gladstone Williams, and this is quite a key case, right? The case of Gladstone Williams, let me try to get the facts. Let me try to get the facts right. I mean, I know the facts, but you try retelling these facts, it's not going to be easy because, yeah, who's going to be defendant, who's going to be the victim. Okay. Now, what happened was that there was a snatch theft, right? There was a snatch theft. So there was this person, this criminal, he went to snatch somebody's bag and he ran away. And then there was this good Samaritan, right? There was this good Samaritan. Basically, he's the victim in this case now. He chased after the snatch thief, right? He chased after him and he managed to catch hold of the snatch thief, right? Of the thief, and he pinned him down to the ground. Again, he pinned him down to the ground, right? So that's what the victim did. He caught the snatch thief and he pinned him down to the ground. Now, the defendant in this case, right, didn't see what happened initially. So all he did, or all he saw was that the victim was pinning down this other guy on the ground. And so he basically asked him, right, why are you doing this? And for some reason, the victim said that, oh, don't worry, okay, I'm a policeman. But actually, he wasn't a policeman. I don't know why he said that. Maybe he was afraid that that the defendant would think that the victim, was the bad guy, and that was in fact what what the defendant did. He thought that this good Samaritan who caught the snatch thief was the bad guy, and that the snatch thief was an innocent person. So, in order to protect the snatch thief, whom he thought was an innocent person, the defendant in this case struck the victim, the good Samaritan. And after that, he found out the real situation, and he was charged for actually inflicting injury onto the victim. And he said that, look, I was acting in defense of that person, of the snatch thief, right, of the thief whom I thought was the innocent victim, right? Those were the circumstances that I believe it to be. And it was held in this case that the jury should be directed that if the defendant may have been laboring under a mistake as to the facts, he must be judged according to his mistaken view of the facts. Right? He must be judged according to the mistaken view of the facts, and that was so whether the mistake was reasonable or not. Now, this has actually again been put on statutory footing under Section 76, 4A, where is provided for that the reasonableness or otherwise of that belief is relevant to the question as to whether the defendant genuinely held it, right? As to the question whether he genuinely held it. So, Parliament recognized, right, that that's the law, right? The law is that at the end of the day, it doesn't matter whether it's reasonable or not. All that matters is that whether he honestly believed it. However, right, and this was also what the court said in Gladstone Williams, and which is now found in this Section 76 4A, the reasonableness of it, okay, is relevant as to whether the defendant honestly believed it or not. Okay, so meaning that the more unreasonable his belief is, the less likely that he would have honestly believed in it. That's what Gladstone Williams said, right? And this is being echoed in this provision, Section 76 4A. Okay, let me say that again. The more unreasonable, right, his belief is, then the less likely it is that he honestly believed in it. Okay? Now moving on, right? The case of Palmer is also important, which provides for that the margin of error is allowed. So sometimes, right, the force that is used may be a little bit excessive, right? And the court recognized that in the heat of the moment, you cannot expect the defendant to calculate very nicely how much force that I'm allowed to use at that point of time. So sometimes the force he used may be a little bit excessive. A margin of error is allowed to when assessing whether the force used was reasonable or not. Now, one connected related matter regarding the assessing reasonable force is a situation which involves people with mental illness, as well as a situation where people are protecting their homes, right, from intruders, right, protecting their homes from intruders. This was decided in the case of Martin. Basically, Martin was suffering from some kind of mental illness, and therefore, when the people broke into his house, he believed that he was in greater danger than he was actually in. Right? He was in greater danger than he was actually in, and he actually killed the people, the intruders, and he was actually charged for for homicide, right? For actually killing those people. And he says that I was acting in self defense, and basically that he, because of his mental illness, he thought that the circumstances were that was more dangerous than than it actually was, right? It was because of his mental condition. He thought that it was more dangerous than it actually was. Okay, now there was no problem with that, right? He can be judged based on the circumstances that he believed it to be. However, the problem here was that the force that he used was not reasonable. Maybe the force that he used was reasonable in his mind subjectively, but objectively no. So there have been a lot of unhappiness over the case of Martin, basically saying that that there should be a different standard. Okay, there should be a different standard, but then that will defeat the purpose of having an objective test. The reason of having objective test is that there must be a standard that everyone must fall to, right? Must fall in line with. So therefore, you cannot having different standards when you talk about an objective test. So when it comes to people with mental illness, there's quite a lot of unhappiness over how the law is. Also, in situations where a person is actually defending his own house from intruders, right? So much so that this matter was quite hot back then, and Parliament recognized it. So, in Section 76, sub 5A, right? This was actually inserted by Parliament in 2013, right? In 2013. So Section 5A was inserted in, which provides that in a householder case, the degree of force used by defendant is not to be regarded as having been reasonable, as he believed them to be if it was grossly disproportionate in those circumstances. Right? If it was grossly disproportionate in those circumstances. Now you compare them with the subsection 6. This was what was in section 76 previously before subsection 5A was inserted. In subsection 6, it says that in a case other than a householder case, the degree of force used by the defendant is not to be regarded as having been reasonable in the circumstances as they believe them to be if it was disproportionate in those circumstances. So you see the difference. If it's a householder case, then it must be grossly disproportionate, right? However, if it was in any other cases, right, he will not be allowed to use, he will not be allowed to rely on self-defense if the force used was disproportionate. So there's a special situation when it comes to householder case. Okay, and finally, right, all or nothing, right? All or nothing basically says that the defense of self-defense is used to either acquit the defendant fully, or it can be rejected. That's all. It's either all or nothing. It cannot be used to reduce the charge to something lower. And this was what was decided in the case of Clegg. Now, the case of Clegg, I feel that it's quite an unfortunate case. Clegg is actually a soldier, a young soldier who was on duty at the checkpoint. Right, he was on duty at the checkpoint. When a car came to the checkpoint, it initially slowed down, but then it sped up, right, and with his legs on. So it sped up to the checkpoint, and what the Clegg did was that he acted in self-defense. He took out his gun and he started shooting at the car, right? Started shooting at the car 3 times. And after the car passed him, unfortunately, he carried on shooting. So the fourth bullet actually killed one of the occupants in the car, right? The fourth bullet killed one of the occupants in the car. And he was charged for murder. Private Clegg was charged for murder, and he relied on the defense of self-defense. So the court said that, well, for those first 3 shots, yes, you were acting in self-defense. But for the fourth shot, right, the car has already passed you. The danger is already over. There's no more need for you to defend yourself anymore. So therefore, the fourth shot, which actually killed the victim in that case, was not considered to be acting under self-defense. Now, the Court of Appeal initially did say that perhaps instead of instead of murder, it should be reduced to manslaughter. But when the matter came out appealed in the House of Lords, the House of Lords made it very clear that that this defense is an all or nothing defense, right? So either he's allowed to rely on self-defense or he's not allowed to. Either he's acquitted or he's guilty. There is no middle line. It's not like the partial defenses that we have seen for murder, like loss of control or diminished responsibility, where murder is reduced to manslaughter, right? Self-defense is not like that. And House of Lords says that even though it may seem to be unfair for Private Clegg, this was something that Parliament needs to look to, and Parliament should be the one that actually amends the law and not the court. Okay, so that brings us to the end of this self-defense. There is a video. It's a funny commercial on Times. You can have a look at it, and then you can then decide and see whether well, basically it's about shop owners and whether the shop owners can actually rely on self-defense or not.